Rashid, thank you very much for that. And I would like to throw that question he's just asked to our guest in studio, George Kithe. He is a constitutional lawyer. Rashid Ronald asks, what next?
Well, the procedure is that once parties or contestants have gone to the National Tribunal within the party infrastructure, there's an appellate process ordinarily the party is required to have, where the dispute will first be heard within the party structure. Then after that, if parties are not contented and they feel they need to go through an appellate process, they go to the Political Parties Tribunal. That is where the dispute is now. The Political Parties Tribunal, for purpose of preservation of the status, ordinarily injuncts the party from submitting to IEBC the certificate. That is like a freeze order. Subsequently, if the dispute is heard, and then the Political Parties Tribunal will make a determination as to then who is the bona fide certificate holder. Most likely, a repeat of those disputed polling stations will also be ordered ordinarily within 48 hours to allow preparation for the party to repeat or hold fresh elections in those polling stations.
So what we're saying at this point, all the powers now lie with the Political Parties Dispute Tribunal?
Yes. The contestants will put in their submissions, will be heard ordinarily within a day, and within 48 hours, if there's a repeat nomination to be done, either in the entire county or in certain polling stations, that determination to be made by the Political Parties Tribunal.
What does this mean even for the political parties, bearing in mind the IEBC timelines that are there as well?
Well, the IEBC, I think there's enough time because the nominations are over officially. But what we're doing now is the phase where we're doing the political the dispute resolution mechanisms that are put into place. Ordinarily, the first stop is within the party's infrastructure in the National Appeals Tribunal within the party. Once that has been exhausted, parties then are free if they're not happy with the decisions of that tribunal, which ordinarily is an internal mechanism of the political party to go to the Political Parties Tribunal. The Political Parties Tribunal is established as a statutory body. It works like a court, and so all decisions have the force of law, and therefore the orders it gives have the power of a court. Ordinarily, the internal party mechanisms, the decisions that are made have no powers like those of a court because they don't attract contempt proceedings. But those of the Political Parties Tribunal will attract contempt proceedings if there's disobedience of its orders. That's why then it's a better forum because of the fact that there's a lot of power in the decisions that are made. More importantly to note is that some of the decisions that are made at the National Party Tribunal within the internal mechanisms may be ignored by the political party if it favors a certain candidate. And therefore, a contestant may want to enforce certain orders or vary those orders if he thinks those orders were not in favor or were not properly made.
All right. Let's go to something else that I would like to pick your mind on. The Independent Electoral and Boundaries Commission is seeking a nullification of a ruling which declared presidential results announced at the constituency level as final. The electoral body insists that it has to confirm constituency presidential results by returning officers before declaring them. As a result, IEBC now wants that particular ruling to be overruled, and Justices Agri Muchelule, Weldon Korir and Chacha Mwita had set aside. The Wafula Chebukati-led commission has faulted the decision for disregarding all laws relating to the conduct of the IEBC. And of course, the presidential election results, in its finding, the bench ruled that IEBC cannot purport to vary, alter and confirm presidential results announced by 290 constituency returning officers on the polling day, as this exposes the electoral system to abuse and malpractice by the commission. All right. From this, we've also seen that NASA has threatened to boycott the August 8th polls if IEBC insists on going ahead to overturn this ruling, that these decisions will be made at the constituency level. But let's start with what the law really says.
Well, the IBC, being an independent body, has an administrative structure upon which it organizes itself. One of it is during the polling itself, the day of the election, there are returning officers who are in charge of the constituencies. Now, there won't be a problem in tallying for the other position because those ones will be done at the level upon which the elections are done. For the presidential, remember that it's a national event,
yes,
as opposed to governors or members of parliament. So that then there's transmission of the results to a central polling station where then the same is tallied, and the sum total is what is pronounced to be the total that's allocated to a candidate or a contestant. Now, the dispute is the returning officer obviously do the first tallying so that then at the constituency level you have the sum total of the votes cast in that constituency for a certain candidate. When that is done, then it is transmitted to the national office or the central tallying center, which ordinarily would be in Nairobi, and by experience last time it was at Bomas of Kenya. If that happens, then it means the returning officer tallies or makes the sum total and then makes the pronouncement himself. The law presupposes, in fact, appoints the chairman of IBC as the chief returning officer in charge of presidential election, and he's the one mandated to do the totals, the tallying, the totaling, and eventually the making the pronouncement. Therefore, returning officer at the constituency level do not have the powers to make that pronouncement, and therefore a pronouncement by a returning officer would not be the final result. But the contestation here is if a pronouncement is made by the returning officer to the total at the constituency level, that is supposed to be the final tally that will be transmitted as the final to the central tallying center, so that all the returning officer, all the chairman or IBC will do at the national level is to add them together, but without any alteration whatsoever. The law, however, presupposed that the chief returning officer, being the chairman of IBC, will receive all this information and make the totals and then make the pronouncements. So the question is before courts, should the pronouncement by the returning officer be final, or is it that he makes the total, transmits, and then the person to make that final pronouncement will be the IBC chairman? But
does the IBC have valid reason towards wanting the nullification of this particular order?
It is about the law. Does the law give the returning officer powers to have the final say in the tallies? Remember, returning officer at constituency level are not employees of IEBC per se. They are contracted and trained for the period of the electioneering process like is happening now. And therefore, do they have statutory powers donated to them by law to finalize, to make that final tally at that level? The question is, there's no express provision in law. However, logic will dictate that, yes, just because that pronouncement is subject to scrutiny by all the people involved in that environment, including the agents of the political parties and the contestants, then it ought to be the final tally, which is the reasoning of the High Court. However, in the Court of Appeal, the challenge is that power donated to those returning officers, and that is the subject of the contestation, against which the NASA says that if that is overturned by the Court of Appeal, they will boycott election, which I think is not the correct position. That announcement or pronouncement was made by Senator Muthama, and not by Raila Odinga, and not by the co-principals to Raila Odinga in NASA. So I don't think it's an official position of NASA either.
But he is among the co-chairs of that particular committee.
Yes, he is. I think it's important to use the side people in order to test the waters, but it is not available for any Kenyan, and this must be very clear, to threaten the courts. The courts are independent, and if the law says that the returning officers will be final, the pronouncement to be final, it is going to be final. If it doesn't say so, that's exactly how the law should be stated.
So should it really matter for these political parties who pronounces this result, whether at the constitutional level or at the national level, by the chief returning officer, who is Chebukati?
Ordinarily, it shouldn't matter. But the problem is, I think there's a past experience, especially in 2007, 2008, when there was an allegation that results were being changed and cooked at KICC, against which certain political contestants were favored by that change. That is the reason why we, in 2008, probably early 2008, we had the problems we had in the country. And that's what the mischief that is being sought to be prevented. But that mischief has to be anchored, the prevention of that mischief has to be anchored within law, and that's why parties are seeking the pronouncement of the courts as to whether that the finality or the transmission then need not be the final, and the same has to be cross-checked by IEBC. Of course, the mischief that was intended to be cured is that the returning officers need to be supervised in their works by the national office, especially the chief returning officer, who is the chairman of IEBC.
So do we expect to come out of the Court of Appeal in the coming days? I know we would be preempting, but given that you're a professional in this particular field,
my position is that the sanctity of the tallying at the constitutional level must be protected, provided that the contestants have approved the same. If it is not approved and there's contestation, then IBC should be able to oversee the contestation and make an oversight and play an oversight role over the works of the returning officer. This again is good for the Kenyan because the sanctity of the vote must be protected at all costs.
All right. Thank you very much for coming in. Judge Kithe is a constitutional lawyer. We appreciate your presence here on a case.